persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting in Boston, within and for the Commonwealth. Draw near, give attendance, and you shall be heard. Now, see the Commonwealth of Massachusetts, court is open, please be seated.
Way up high. Thank you. Good morning, and welcome to the. I'm gonna say a few things, so it's you can. I don't want you to. You don't have to stand there quite yet. Welcome to the Appeals Court. Today is February 11th, 2026. Your panel today is me. I'm Justice Massing. To my right is Justice Neyman. To my left is Justice Smyth. Rules are pretty simple. 15 minutes for each side. No rebuttal. We have read all your briefs, and they're on these handy tablets or computers. So if you see us looking at screens, it's not. It has to do with the case and nothing else. Like as I said, you have 15 minutes. You're free to use it all, but you're free to finish early. There's no penalty for finishing early. We'd also like to welcome Justice Granger and his class from BC Law, who is observing today. Welcome. And with that, I'll call the first case, which is 25P402, Weslin versus Murphy.
Good morning, Your Honors. May it please the Court. My name is David Eisenberg, and I represent the appellant, Mark Murphy. Mark is an attorney, and for 10 years he had a law partnership with Richard WULSIN. WULSIN asked Murphy to join the partnership because WULSIN was looking for an exit plan and expressed the goal of transitioning his practice to Murphy. The partnership ended in 2015, and the current dispute centers around the breakup and the reasons for it. While both Murphy and WULSIN are lawyers, they did not always document their interactions formally. Instead, almost all their agreements were by email. There's a summary judgment decision below and a decision after trial. Both are the subject of this appeal. We are asking the Court to reverse the summary judgment and allow all contract and fiduciary duty claims to be tried. The primary issues on appeal are whether Mark owed a guaranteed amount to WULSIN on December 31, 2015, and whether WULSIN breached his obligations to Mark, either under the contract or fiduciary duty.
So as I understand it, with regard to the purported amendment to the side agreement, you are relying on, what's it, Record Appendix, Volume 4, pages 192 to 194, which is the June 19th, 2014 email exchange. Is that correct?
That's correct, Your Honor.
Where is the meeting of the minds there?
So the meeting of the minds, Your Honor, is that interaction is an exchange between WULSIN and Murphy. And WULSIN started the exchange, Murphy responded, and then as the Court can see on the electronic appendix, there's color coding. And Richard then responded to Mark in yellow, Mark in green, Richard in turquoise, and then Mark in gray. The meeting of the minds, Your Honor, is where Richard starts off the conversation, and he's talking about the future of the firm. And at that time, Richard's two children, Seth and Rachel, also worked at the firm. And he was talking about how the three of them would need to work together.
More than aware of the context, so explain to me where the meeting of the minds is with precision, please.
So Richard starts off the conversation. He says, over the next 5 to 10 years, and he says, I would keep your pay at $250,000, assuming you can live with that. And the excess would go to the rest of the team. And then Mark responds, I think the current approach where we will share the excess profits works well. And Richard says, I agree. So right there, there's an agreement. Mark's salary is going to be $250,000, and that the excess profits would be shared among the three of them.
What about the statement after? It's my hope that as I fade into the horizon, you, Seth, and Rachel will be the nucleus of the firm, and at some point the three of you will share net income. On the other hand, Rachel may decide to have a family and only work part-time. Things change, notwithstanding my hopes, and my hopes are just that, my hopes. Nobody else has to share them. They don't have to be implemented.
But it continues, Your Honor, after that, where Richard then raises the guaranteed amount. Now, if it were set in stone and he wasn't making a proposal about the guarantee, there would be no need to raise the guarantee because under the plain language of the side agreement, it was due December 31, 2015. And as Your Honor knows, the parties had already amended the side agreement orally because the side agreement on its face only covered the first 2 years. And after 2 years, the amount of the guarantee was only $130,000, but by the time of the case, it had been expanded to $308,000.
So if there was a meeting of the minds, why in subsequent emails did both parties then raise the issue of the guaranteed amount? One party saying at one point, look, I'll get back to you on when this is due. The other party saying, hey, pay me the guaranteed amount by this date. That strikes me as evidence that there is not a meeting of the minds. It strikes me as evidence that that email from, June 19th was what it was captioned, the future, and these are my hopes, and I want to discuss some possibilities about the future.
Well, before I get to that, Your Honor, I would like to continue further with the June 19th to July 1 exchange, where Mark says when Richard raises the guaranteed amount, Mark says, I agree, we need to discuss it. And then he goes, in years where we have a bonus pool to share. So that, again, that's consistent with Richard's concept that Mark would have this salary and the bonus pool would be shared. When we have a bonus pool to share, I would hope a healthy chunk of the bonus that would have gone to me will go to you instead. Is that approach okay with you? Richard says, yes. All I have to do is outlive my money. So right now, we have a plausible understanding from Mark's perspective that there was an agreement. And that plausible...
Isn't the side agreement a separate agreement then, other than the firm agreement?
I'm sorry,
Isn't the side agreement for the loan, isn't that a separate agreement? It seems like you've incorporated that into an agreement about the pool of money for the firm. Are they different pools or different agreements?
Well, there were two separate agreements. So there was a partnership agreement and there was a side agreement. And one issue of fact that the court, I think, would suggest was inappropriate to decide on summary judgment was whether those were two agreements or one. And we cited a case in our brief that suggests that that's an issue of fact that should be determined not at summary judgment as the court determined, but instead at trial based on the understandings of the parties and whether those should be one agreement or two.
What difference does it make?
Well, it makes a difference, Your Honor, in terms of the breaches that occurred subsequent to that. If they're one agreement, then the subsequent conduct of Richard could be a violation of the entire arrangement between Mark and WULSIN with respect to the guaranteed amount when it was due and his obligations as a 50-50 partner with Mark going down the road. And what they had here was an agreement from Mark's understanding that the guaranteed amount had been extended based on this 2019 exchange, and that the subsequent emails between the parties have to do with Mark. At that point, he's defending himself and trying to keep the firm together. And so you could argue that those were, in essence, settlement discussions as opposed to unwinding this agreement that they had in 2014.
Did any of the email exchanges have the, and I can't remember the rule, but the statement for settlement purposes only, or cite to the rule that indicates that the discussion is for settlement purposes only?
None of them have that, Your Honor. But I'm not sure that that totally makes a difference given the chronology of events here, because we also have the April 30th email, which is at pages 196 and 197 of Volume 4, where Richard continues the discussion. And it's also important to note that a big change here is that Rachel passed the bar in December of 2014. So when Richard's sending this email in earlier 2014, the only lawyer in the firm was Mark, and he was transitioning the firm to Mark, and he's discussing, and Mark's agreeing, that this deal would be extended. And the initial discussions in 2015 continue along the same lines. And he then couples the whole issue of making Rachel a partner. And he says in this email, I don't think anyone can easily take a pay cut. However, I think the goal over the next 5 years should be to equalize what the three of you take out of the firm. Well, that's consistent with the concept that Mark would have the additional time to repay the guaranteed amount. And Mark says, I'm in 100% agreement with you on all points. So again, these things are coupled together, making Rachel a partner, extending the time for repayment of the guarantee. Richard just wants to outlive his money. He's not pressing Mark on the December 31, 2015 date because they had agreed to the extension in 2014.
So let me ask you, one of your arguments is that your client is off the hook for the guaranteed amount because of a subsequent breach of something by Richard. What was the subsequent breach of what?
Well, the subsequent breach, Your Honor, is Richard's conduct moving forward, his breaches of fiduciary duty, how he teamed up with Rachel, his
and what is he breaching?
He and Mark are 50-50 partners. The chronology goes on.
And that's under the partnership agreement. The 50-50 partners under
They're
the
the only
partnership
two
agreement.
partners. They're the only
Right,
two
right,
equity
right.
partners in the firm.
Yeah.
And what Richard does is on June 3rd of 2015, he makes a deposit in the firm bank account. And the ray line on that, and this is at pages 209 and 210 of volume 4. And the emails, the ray line is more on the WUMU cash flow. WUMU was how they named the firm, WULSIN, Murphy, WUMU. And he goes, after discussing the situation with Annie, I have deposited another $40,000 in the WUMU bank account. Well, there's no mention that that money was a capital contribution for Rachel, but as set forth, and this is in the appellee's brief as well as our brief, on June 16th at a meeting, Richard announced that that deposit that he had made on June 3rd was not cash flow. Instead, it was a capital contribution on behalf of his daughter. So what in essence is happening is Richard hatched this plan after Rachel became a lawyer so that he and Rachel would have a majority in the firm and Mark would essentially be subservient to them and their decisions. And he's making this decision to put the capital contribution for Rachel in the bank account without any discussion with Mark. He did it without even telling Mark that he was doing it or having Mark's permission. And in fact, Mark...
I understand your argument that that's a breach of fiduciary duty, which went to trial. What is your argument that it's a breach of contract?
It's a breach of contract to the extent that these are both 50-50 partners. And one partner can't do something without the permission of the other. Even if it's not in the written agreement, they're both 50-50 partners. So it would be a breach of his contractual obligation to the other to do something that the other partner hadn't authorized. That would be the breach of contract.
So does even broaching the subject of bringing Rachel in, is that a breach of the contract?
It's not a breach of contract because he's broaching it with Mark. He's saying, Mark...
so this is a breach because it's unilateral?
Yes.
Okay.
And it's changing the whole firm. It's essentially creating a new firm without giving the 30 days notice that was required under the partnership agreement. So in essence, by now having two equity partners instead of having three equity partners instead of two, it's a new partnership.
I've got to ask you a really dumb question, but I mean, it's not that dumb. I need to have to understand. Back to the original, in the future email from RA4, 190, 192, there's a part where, in the key sentence actually, he says, let me just find it again. On page 193, over the next 5-10 years, I will slow down, I will draw less. As I draw less, I think Rachel, Seth, and Andrew should make more. Who's Andrew?
I honestly don't know who Andrew is.
Okay.
I didn't try the case.
Is Andrew Annie?
I apologize.
There's an Annie, right?
My understanding is that the future of the firm was Seth, Rachel, and Mark, and Richard until he transitioned out. I have no understanding that Andrew was part of the future of the firm.
You don't even know who Andrew is?
I do not know who
Okay,
Andrew is.
okay.
I want to go back to the purported amendment. Would you agree that typically whether or not a contract has been amended or modified is a question of law? Typically, not always.
Typically, it's a question of law, but it's also, if there are two plausible interpretations or understandings, particularly where these two lawyers did stuff by email, if Mark's understanding is a plausible understanding, just as Richard's understanding is a plausible understanding, that's an issue of fact that needs to be tried, and it's dependent on the credibility of the parties, and it shouldn't be determined on summary judgment.
Understanding of what? That there was an extension or understanding of the contract itself?
Understanding of whether this language in this email constituted a new agreement in terms of when the
Is it a new agreement or a modification?
I'm sorry.
Is it a new agreement or a modification?
I'm not sure the difference in this context. I would say that what they've done is essentially continuously modified the agreement, given that, as I said, the initial written agreement only provided for monies for the first 2 years, but subsequent to that, additional monies were given by WULSIN to Murphy, and those became the total guaranteed amount. There's no written document where those additional monies are established under the same guidelines as the original agreement.
So your best case to support the proposition that this was an issue of fact, at least in part, that is the amendment to the side agreement regarding the guaranteed amount, is that the Arthur D. Little case or a different case?
Well, it would be the Arthur D. Little case, but as I said, it's also that we have two plausible interpretations. The words agree are used in the email exchange. We're talking about what the parties understood when they use certain language, if this is the way they always communicated, through email. So it requires an entire understanding of their relationship and how they understood each other's communications. You know, the words agree are used. And Richard unequivocally says, yes, I just need to outlive my money. So to me, well, I would suggest that that's a plausible understanding of that, is that he's not holding to the December 31, 2015 timeline, because he's suggesting that I'm going to do this over the next 5 years, and you can pay me through the excess profits, because that's what Mark suggested. And that concept also comes up in the hand grenade email.
Your time is up, but you can finish your answer.
Yeah, no, I've got some more questions too, so keep going.
I would suggest that it also comes up in the hand grenade email where Richard raises the issue, what does Mark think he's going to do? Repay me with the bonus money over time? And the only reason Richard could say that is because they had this agreement in 2014, and that's why he's bringing it up to his kids, because Richard is actually proposing that, you know, the kids then use to their advantage the fact that there was this agreement to extend the time, because Richard doesn't want to be on the front end saying, I'm breaching my agreement, but we now have the leverage.
Well, I mean, isn't he saying you should leverage the due date of 2015?
That's what he's saying, because he knows that he can't leverage it because he had the agreement with Mark in 2014 that it would be extended.
So what do you, and I think Justice Neyman answered this, and you said you'd get back to it, we never did though. Subsequent emails, your client seems to act as if the deadline is still there. He says, at one point he says, it's going to take, you know, we'll pay it from the profit, we'll pay it as we wind down from the profits. It'll take about, as we get the payments in, it'll take about 3 or 4 years, which is much less than the 10 years that he, at his deposition, he said it had been extended for.
But all those emails, Your Honor, were after the hand grenade email. They were after the June email where they proposed that Mark be of counsel, because now they have the family leverage of Rachel and Richard being a majority owner. And then after that email, they have the email where they're going to change the firm name to WULSIN Law LLP.
So why doesn't your client say, but I've got 10 years to pay this off? You agreed. We have this agreement that I've got 10 years.
Well, the payment was going to be from the profits of the firm, and keeping Mark's salary at $250,000, and they essentially took that away from him. And you know, at this point, Mark is trying to keep the firm together, to do what he can to keep the firm together, to stay in the firm.
I'm sorry to interrupt you. I want a few more questions I want to get done with the time winding up. It's counting up now after the 15. The Richard side makes an argument in their brief that there was a motion to dismiss where the judge said your tort claims, I guess, are limited to the amount to offset his contract claim because they're late, and you're not challenging that. Is that correct?
That's correct, Your Honor.
Okay. And so, what are your and it looks like the wind down. There's a lot of subsequent email about sharing profits and spreadsheets and money being paid, and your client takes money out, Richard takes money out. All that seems to be pretty fair and kind of subject. You know, they're very. It's you know, there's not. It seems like it's fair. And so, what are your client's damages?
Number one, the damages are whether he has to repay the guaranteed amount based on a material breach of contract from Richard. Secondly, in essence, Richard terminated the partnership agreement without giving 30 days notice, and then their conduct forced Mark to terminate the partnership.
But so, I mean, but it looks like the money was all allocated pretty fairly. What are his damages from the termination of the partnership? And they make an argument that Mark is still getting business from, from Richard's clients.
Well, the damages could be as well, Your Honor, the 40% that Rachel took, where she shouldn't have been, her 20% that she took, where it was never authorized that she be an equity partner of the firm. So those could be his damages.
Okay. And what is the relevance of these allegations that Richard engaged in academic fraud with Rachel? What is the relevance of that at all?
We haven't raised that on appeal,
Okay.
Your Honor.
Good. That's good. And
I have one more question.
yeah, go ahead.
You argue in your brief that the judge made a clear error of fact in determining that it was your client who dissolved the partnership, correct?
Correct.
How do we reconcile that argument with the July 21st, 2015 email where your client writes, as a result, and I won't read the rest of it, I've reached the conclusion that the best alternative is to dissolve the firm and go our separate ways?
Well, one question, Your Honor, is whether it had been dissolved where Richard elevated Rachel to an equity partner without disclosing that to Mark, and whether that dissolved the firm prior to anything that
So
Mark did.
that's a dispute of fact, which the judge gets to resolve at trial under the clear error standard. So again, how can that constitute clear error? How can the judge's determination constitute clear error in light of Murphy's email where he says, we need to dissolve the firm?
Well, it could be clear error, Your Honor, to the extent that, again, all of this derives and flows from whether the side agreement had been amended. And if the side agreement had been amended, then the subsequent events all followed from that, and none of those would have been able to follow if the side agreement had been amended. That Mark would have had, the right to use the firm over the next 5 years, and Rachel would not be an equity partner because they never agreed on that. And again, Mark has his back against the wall. The rug had been pulled out from under him, and now his back's against the wall. They've made him of counsel. They changed the firm name to WULSIN Law LLP. He's basically subservient to them. He has no other choice other than to dissolve at that point.
Okay.
Thank you.
And does your appeal, are you also appealing the summary judgment against Weslin Law and Rachel, or just Richard now?
No, just against Richard, Your Honor.
Okay, that's helpful. All right, thank you. Any more questions?
Thank you, Your Honor.
Thank you.
We rely on our briefs for any additional points.
We'll rely on your briefs, too.
May it please the Court, Christian G. Sumito appearing for Richard WULSIN. As the Superior Court correctly found, there is no language anywhere in the email chain sufficient to constitute an amendment. And in fact, the only reference to time comes in a single sentence when Richard says, over the next 5 to 10 years, as I slow down, I will draw less. Richard is talking about his retirement, not amending Murphy's guaranteed amount repayment due date. That doesn't come up until much later in the discussion. And to correct Attorney Murphy's counsel, Murphy raised the guaranteed amount. Richard never raises the guaranteed amount in that email chain.
No, that's not right. Richard says we need to discuss the guaranteed amount.
Okay, then my error on that. If that says that in the email ping pong.
And then Mark says, I agree. And he says, in years we have a bonus to share. I hope that a chunk of that would go to you. Is that approach okay with you? And he says, yes.
Right, and the bonus pool payments were already in the side agreement, so that was nothing new. That was no amendment to anything. When you look at the side agreement, it says it could be paid out of bonus pool from the firm. And as Justice Neyman pointed out, and it makes sense because you were on the Seabreeze case on which we rely, Murphy's own behavior confirms that his argument is fiction, because not once during the firm's dissolution does he ever say, we amended the side agreement. I have this extra time in which to pay. In fact, some of his proposals are moving that 5 to 10 year period up that they now rely on. During dissolution, Murphy proposed various schemes to avoid paying the debt, but decisively, Not once did he ever claim that that side agreement had been amended. That was a theory developed during litigation. Ambiguity, to the extent that they're saying there's ambiguity in this email chain, ambiguity is not created simply because a controversy exists between parties. Murphy may not like the facts, but there is no genuine dispute about them here. Murphy's behavior confirmed was clear on the face of the emails. And where the evidence of purported contract formation or amendment, quote, consists only of writings or is uncontradicted, it's an issue of law for the court. This is the Tierney case. Now, in that case, there was conflicting testimony about the contractual negotiations and what was going on, so there was a jury. But where the purported contract formation or amendment is only by writing, it's a question for law. And here, the only thing on which they have to rely are those email chains. So it's clearly done by writing. We don't need extrinsic testimony to try to alter anything. We can look at what the parties said in that email back and forth and see whether there was a meeting of the minds. And where there was no extension, the only discussion about 5 to 10 years was Richard saying, I'd like to retire in the next 5 to 10 years. That's not a meeting of the minds about any contract amendment. And transitioning to the second part of Murphy's appeal,
Actually, before you do that,
Sure.
I have a question about whether or not the agreements are integrated. And I understand that your argument, your backup argument is it doesn't matter, but let's put that second part aside for right now. Why is it the case that as a matter of law, I think you're saying, that the partnership agreement and the side agreement are not integrated?
Because they're two separate agreements. And you can have, this goes to the...
Does either one have an integration clause in it?
They don't, but in the Busfield case, you had 3 related contracts concerning transferring of a business. They didn't have integration clauses, and this court held that even though they were executed on the same day, concerned the same parties, each contract was comprehensible on its own without reference to the other. Here, the partnership agreement governs, it forms and governs a partnership. The side agreement concerns a loan. The partnership agreement could be terminated within 30 days written notice. The side agreement exists until the loan is repaid. They are two completely separate documents that are comprehensible on their own. Now,
Are you making that argument as a matter of law or as a matter of fact?
It's a matter of law.
Okay.
And if I may move on to the breach of fiduciary component of the argument that Murphy makes on appeal.
One more I think this might be more contract than fiduciary. What is your response to Mr. Eisensberg's argument that the capital contribution, he pointed to a record, I'm putting in $40,000, is a breach of the partnership agreement?
I'm very glad you asked that question. Murphy consistently says he was blindsided by this capital contribution and the concept that Rachel WULSIN became a 20% partner. He testified, and this is not only in emails, but in his testimony, he voted to make Rachel partner.
Is that a trial or a deposition?
At trial.
Okay.
And luckily, these two parties did communicate very extensively by email, so there's emails that are laid out. He voted to make Rachel partner. He testified at trial that he understood when he set her draw, when he agreed to set her draw at $125,000, that created a 40-40-20 percentage between their annual compensation. When I asked him at trial, I mean, this is actually very telling. These are questions at trial, and this is at Record Appendix 6, 31 and 32. You agreed to set draw for Rachel, so that was a 40-40-20 proportion between the 3 partners, correct? Correct. And you acknowledge that the capital contribution on behalf of Rachel, again, set up a 40-40-20 proportion, correct? Correct. So she had a 20% ownership in WULSIN Murphy? Yes.
Yeah.
And
so I'm a little confused with, the contract claim was dismissed, was decided on summary judgment, so before any of that testimony, right? So the judge must have found that there was that whatever disputes there were about this capital contribution did not breach the contract.
Correct. All these emails and this whole issue.
Why didn't they breach? Why didn't they? Why isn't he? We have a 50-50 agreement, and now I'm making it you have less now.
Because he voted to make her a partner. He voted, and then they set up, and all throughout, even through the dissolution emails, they consistently use this 40-40-20 formula. And there's even, I need my reading glasses for this one, but if you look at Record Appendix 5, 232, this is an email from Murphy where they're talking about the capital contribution, and in Murphy's words, when Rachel contributed her $40,000. The first time he objects to this concept of a capital contribution for Rachel comes on September 12th. But all through June, all through July, all through the dissolution process in August, he keeps referring to her, and they divvy up profits 40-40-20 after June 1st, after the date she became partner. He keeps referring to her capital contribution. It was only in September that he decided, I'm going to object to this. So I don't think that you could vote someone in as partner, set the draws at 40-40-20, testify that she had an ownership share. His behavior during the entire dissolution process was to respect her 20% ownership after June 1st, and then for the purposes of ginning up an argument to try to avoid paying a debt, say, oh, I object to her ever becoming a partner.
So I understand that, but so you're saying that there wasn't a breach of the partnership agreement at the summary judgment stage here because there's actually an agreement to amend it?
No, it's actually a little more nuanced. What the parties did is they had this initial partnership agreement, and then in 2010, they began to, as they started bringing staff on, they amended things informally where they decided to each take around a $250,000 draw and start paying salaries. The other thing is Murphy always had an office. WULSIN worked from home on the Cape, and so they ended up splitting expenses. So it actually worked to Richard's disadvantage because now he's paying for this office that Murphy is using. But they end up splitting the expenses.
And that's contrary to the partnership agreement.
And that's a change from the partnership agreement. And they do that in emails every year.
Wilson's kids use that office too, right?
Once they become hired, they're using that office too. Correct.
You know who Andrew is?
Andrew, I believe, was a cousin who worked there briefly.
Okay.
He wasn't a major figure in this.
And forget
I did mean to answer that question because, yeah.
Okay.
I just have one more question about the June 19th, 2014 email. I should have asked this of Attorney Eisenberg, and I apologize for not doing so. But the color coding, does that signify, well, I think I understand what it signifies, but was the entirety of that email exchange written on June 19th of 2014?
I think it may have, I don't know the answer to that question,
Okay.
to be honest. I don't know if it spills over into, I think the last day would be the very first email where you see someone say, I'm running out of colors. I think that might be the very end of whatever that very top email is. But I can't say I recall.
Yeah, if you go back to page 190, you can see the colors beginning. There's a blue and the green and the yellow.
Yeah, I think it's that gray. I have it in front of me now. And so it's July 1st with Murphy saying, the umpire just told me that I'm running out of colors, the gray.
Okay, so it represents an ongoing dialogue, but the exact dates of each color-coded statement are not clear,
Right.
as far as I can tell from the record.
Well, I think you could probably look in the emails and see the colors and extrapolate out.
I'll do so, thank you.
It looks like the last piece is July 1st. Is the
Correct.
When the gray is introduced. So I stopped you before referring to the trial testimony, but it seems like in Judge Kazanjian's findings after the trial, she said, I'm going to address some of the things that were foreclosed by summary judgment, but they sort of overlap here, and I'm going to address those too. Can we use her findings at trial to assess the summary judgment decision?
No, because what happened at summary judgment is the parties moved for cross summary judgment also on a lot of the breach of fiduciary claims. Murphy had all sorts of breach of fiduciary claims. He had claims after he agreed to hire Rachel for years that was a breach of fiduciary duty, that he hired Rachel and that he hired Seth. He really threw anything that he could think about as a grievance. And so a lot of that also got eliminated on summary judgment. And what the judge said in the summary judgment record is there is some circumstantial evidence concerning the windup and dissolution of the partnership, so we will have a trial that's focused on the windup and dissolution of the partnership. And the trial focused on making Rachel partner. And again, he agreed, the record is replete where he said he agreed to make her partner, the draw, the ownership share, et cetera, and the windup. And as Your Honor noted, there was nothing unfair in the windup. Most of the proposals are things that Murphy proposed, and he said, this is what I propose. This is how I think we should go down the list of assets and divvy things up. The one thing that Richard proposed was the division of clients, and Murphy responded, that looks fair to me. So there was nothing that he objected to in the course of dissolution. The thing they objected to was the idea of having to pay the guaranteed amount when that came up. And I do want to point out, under Murphy's theory, any time two partners talk about leaving a firm or starting a new firm or doing anything, it would be a breach of fiduciary duty. The concept that Richard and Rachel decided this isn't working out, that's not a breach of fiduciary duty. The breach of fiduciary duty would have been had they done something unfair during dissolution, had they taken all the money, had they said to Murphy, we're not letting you have access to the QuickBooks and the bank account and distributions in an agreed upon proportion. That never happened. And the judge correctly found that during dissolution, the only party that ever raised the guaranteed amount was Murphy. He kept coming up with schemes to try to get out of repaying it, and he kept trying to leverage it. But the WULSINs never raised the guaranteed amount. As far as Richard was concerned, that money was due December 31st, 2015. And so the Superior Court gave Murphy every opportunity to present his case. In the summary judgment ruling, it said there was a sliver that had, at best, some circumstantial evidence, and the judge was careful with the Rule 56 standard and said, okay, you get a trial on that area where you have some circumstantial evidence, and it saw through Murphy. He had credibility issues making up arguments, and I cite in the record a couple instances where she has to say, that's not in the email. You're reading things into the email that don't exist. That goes to your credibility. So I'm going to close by paraphrasing.
Just have a comment.
Okay.
Do you have any questions?
Yeah, your time is up, so I think we're going to get to the question and answer.
I just want to state for the record, so that we can avoid a Rule 22 letter, that Record Appendix Volume 4, pages 190 and 191, essentially explains the key for the color coding and the dates on which the emails were sent. So that's clear. I just wanted to let the lawyers know that. All set.
Any questions? Okay, well, that's Tom. I just one question were both of you trial counsel as well as?
I was trial counsel.
Was
I've
Mr.
had the
Eisenberg
case
too?
throughout.
Was Mr. Eisenberg too?
No, he was not.
Okay. Well, thank you both. I mean, you both, obviously know the record very well, and it's very helpful to us. So we appreciate it, and the case is submitted.
Thank you very much, Your Honor.
Okay, this next case we have on for this morning is 24P1057, John Doe number 739 versus Sex Offender Registry Board.
Good morning, Honorable Justices.
Just let
sorry.
let the other
My apologies.
Yeah, no worries. Just in terms of prefatory remarks, the case is impounded, so we'll refer to Doe as Doe. This is one of the lowest numbers I've ever seen. Are you, okay, go ahead.
Thank you, and I apologize for my overeagerness there. I'm not sure there's a rhyme or reason to the numbers as such. So I won't repeat the arguments in my brief, but I'm really focusing on the expert testimony angle. And I would summarize it by saying that the examiner in this case used clinical treatment status, as she refers to it, as a risk aggravator without giving my client the opportunity to have expert testimony on the same issue. So on one hand, he's denied the use of expert testimony in the form of Dr. Brown. On the other hand, she goes on to make conclusions, clinical conclusions, about the impact of Doe not using medication.
Well, did Dr. Brown's proffer discuss the impact or potential impact of medications on Doe's risk of reoffense or dangerousness?
I believe he does reference it, and I'm sure he would have talked about it.
My question is whether so where does his proffer reference the impact of medications?
I apologize, I'm misspeaking. I don't know that it does actually, now that I recollect it. And my point is essentially that if that had come up, he would have had an opportunity to opine on those issues. And I don't think to the extent it doesn't mention that, Your Honor, I don't think it would all be precluded from that. But as the examiner...
Did his proffer in any place or his affidavit discuss a correlation between medications and Doe's risk of reoffense or dangerousness?
I don't believe so, Your Honor. But I don't think that's the central issue here, that he was required to do that. And, because he was saying he was going to testify about a constellation of issues that I think are very particular to this offender, specifically bipolar.
And before you continue, at
Yes, Your
Record
Honor.
Appendix 57, paragraph 7, the affidavit of Dr. Brown does mention that Doe received psychotropic medications.
Okay, my apologies for any lack of familiarity with Dr. Brown. I think my point, the idea of Dr. Brown was to have a fulsome discussion of the offender's clinical conditions and the impact of those on recidivism. And I think that would have been to the benefit of the tribunal, because she goes and looks at these earlier documents, the 2003 report from Dr. Schwartz, which mentions in passing medication and impulse control. The Dr. Lewis report is much more fulsome on that issue, and that's where the mention of Lamictal comes up. And then she also relies on the 2006 classification decision, which talks about the use of SSRIs. All of that's pretty dated information. The newest of it is 2014, and her opinion says this admittedly dated information. So if you're, as an examiner, going to look at these reports and say, this petitioner benefits from medication, and his niece says he's not on medication now, that's concerning. That's a risk-aggravating factor. Why is it fair to have that occur, but also excise Dr. Brown?
Is that the same question, the fairness question, is whether or not Doe met his burden for the expert? Is that really the same question, or is it a different question? Because you'd concede he has the burden, correct, Doe, to show a connection.
Yeah.
So the unfairness you're referencing to, is that the same, or is that a different inquiry?
I think they're both, there's fairness involved in both. The case I cite, which is, I don't have the Doe number, but it's 452 Mass 764, references expert testimony concerning bipolar that would have been helpful to the tribunal. So the regulation refers to the phrase special to this particular individual. And I think the question is that being fairly applied in this case? And, Dr. Brown is eminent. I mean, he's testified robust, countless amounts of times before Sorb. And what he's proposing to do is say this gentleman is 65 years old at the time of the hearing. He's got two complicated clinical conditions. And that these things together, and then there's also the desistent science that is in the, that was submitted below. So I think that more than meets the standard of being a case special to him where this would have been helpful to the tribunal.
But if we agreed with you.
Yeah.
Well, let me take a step back. In Dr. Brown's affidavit, it seems to me the key proffer,
Yes.
the key averment, is number 9. There is no scientific evidence that a diagnosis of bipolar disorder or schizotypal personality disorder correlates with sexual or non-sexual criminal behavior. And then I think the key line for Dr. Brown is, however, a diagnosis of these comorbid mental disorders may complicate the evaluation of risk, treatment needs, and risk management strategies.
Yeah.
That's the key proffer. If we agreed with your argument that that is sufficient to meet the burden of showing that this is special to this person, to Doe, then it seems to me that an expert would be required, or at least would go to every person who had those same diagnoses. I know it's a long question, but I guess my point is that strikes me as being an overbroad proposition by you.
Yeah, well.
Understand my poorly phrased question?
No, no, Your Honor. I think it's a very well phrased question, and I think it's worth taking a look at the case I mentioned for the requirement not being especially narrow. I think any given examiner would have to look at the specific proffer, and you have the proffer in this case, and Dr. Brown is not saying every single person with bipolar disorder should get an expert. He's saying that, given this particular constellation of facts, including age, schizotypal disorder, personality disorder, and bipolar, that, he's making the case that he wants to, sort of opine on these issues, and he wants to conduct an examination. And meanwhile, there are these examinations earlier, but why is an examiner, why wouldn't you want this current information? The doctor's saying, I'm ready to have at it here, and the examiner says no, but meanwhile, I'm going to construe these earlier reports and functionally hold them against you, find them to be aggravating. So I think that's, these are all due process cases. I think it's worth remembering that. It's Sorb cases always sound in due process because everyone has a right to not be on the registry, a constitutional right that cannot be overcome by unfairness. And to me, it is the essence of unfairness to make clinical conclusions that are forward-looking. They're not just looking at the report. She's then engaging in clinical observation.
You weren't counsel before the board, were you?
I was not, Your Honor.
So let me ask the question this way. I'm trying to get at Justice Smith's excellent question, which is this. Let's assume for the sake of argument that Dr. Brown's affidavit was insufficient.
Insufficient,
to
okay.
warrant expert funds.
Yes, Your Honor.
However, then after the decision came down, where the hearing examiner got into the potential impacts of medication or the failure to take medication on Doe's likelihood to reoffend and dangerousness, is there a mechanism by which prior counsel could have either a motion to reconsider or some other mechanism by which prior counsel could have brought this issue to the attention of the hearing examiner and said, hey, wait, you didn't give us funds for an expert. Now you're opining on the impact of medication. So I'm going to come back with another affidavit from Dr. Brown explaining what his opinion would have been on the impact of failure to take medication. Could prior counsel have put that before the hearing examiner?
No. I don't believe so, Your Honor.
No post-hearing mechanism for a motion to reconsider or a motion to take further evidence or anything of that nature?
My brother is a much longer expert in these cases than I am, and I'm sure he's
coming attractions.
I'm sure he's going to get up and say there's a minute part of the regulation that allows this. I don't believe there is. I mean, obviously it's a dense group of regulations. So you're saying basically, given that he didn't know, he didn't know necessarily trial counsel, hearing counsel, my client's counsel, he didn't know that the examiner was going to think about it this way. And then after the opinion comes out, was there some mechanism? I don't think there is, Your Honor. Again,
Because you're saying Dr. Brown could have responded to this with X. Here is the impact or non-impact of failing to take medications on likelihood of reoffense and dangerousness. That strikes me as speculation without an affidavit from Dr. Brown saying so. But that's what I'm wondering. Could there have been a mechanism there to reopen the hearing or to reconsider using a supplemental affidavit? And again, I'll ask your brother that question if you
I mean,
don't
so
know the
I'm
answer.
just trying to think of what the mechanism might be. So we have an opinion that closes the matter. It's a final order. I think the empirical question is there a regulation somewhere that says, can you bring a motion for reconsideration the way, most Superior Court practitioners, when it's a motion for anything, bring a motion for reconsideration. I have not heard, and again, I defer to the expertise of board counsel. He's been doing this longer than I have, but I have not, in fairly robust amount of work on the appellate level, seen a case where trial counsel did so after the fact. So I don't know that there would have been a recommendation, but a mechanism. But I understand the gist of the question, because I don't think he could have anticipated it. But here's the thing: the examiner herself engages in some questions multiple times of witnesses. So she was not a shy individual about examining witnesses. I don't think there was any problem with it. I think it was helpful. This would have been an opportunity to have everyone ask Dr. Brown questions. If this examiner, who's looked at the record, certainly looked at the record, it's a thought, basically methodical opinion other than this, if she had looked at the record and had planned, to get at this issue, and this issue is in her mind. She's looking at these reports and she's thinking going into this, boy, this is, a relevant issue that, he's got docs that are saying, they're not doctors necessarily, but they are saying, boy, this guy benefits from meds, and if he's off meds, that's going to increase his risk. If she's thinking about that, let's have Dr. Brown up, and she's going to ask him questions, and everyone can ask Dr. Brown questions, and it's not necessarily a medication case or not a medication case, but these issues are so complicated, and science changes over 20 years, 23 years on these questions. And the reason I asked the court to take cognizance of the material on Lamictal, it's not hugely probative, but I think it helps illustrate that whether or not to take a medication is a very personal decision. I mean, Lamictal, this mood stabilizer that may have helped him, that she feels, well, if he'd been taking some medication, she doesn't refer to it by name, but she does refer to mood stabilizer, that it's reasonable. Just, I wanted the court to have the benefit of being able to think about it. It's a consequential decision. This medication can kill people.
Go
ahead.
Your brother may, well, I'll just ask you, is that issue waived?
The Lamictal issue?
Yes. Did he raise that below to Doe?
Well, he didn't specifically raise an issue because, again, he wouldn't know what was going to be said by the examiner. But I think by virtue of...
But he had the reports. He had the doctor's reports that reference that.
I'm not sure what he was supposed to say in that regard to preserve that. And I'm not arguing necessarily it's a determinative legal issue somehow, but I think it's just instructive on the question. I don't think it does any harm for the court to look at it and just kind of think about, well, she's kind of saying black and white, hey, take some medication, it's going to help. Other people have said that it's not that simple as just sort of ingesting something and your risk goes down.
I watched the Super Bowl. It seems like any medication can kill you.
What's that?
I watched the Super Bowl. It seems like any medication can kill you. It seems like it's a side effect of just about everything.
Well, it's true. Every medication has these, endless list of things. But Lamictal has a very, very common side effect profile of rashes that can exist in your throat. It's not a trivial or uncommon thing. I mean, I don't know the exact, but it's. I don't think this is just sort of a. Sort of pro forma, once in a while, something happens, to everyone when they take this drug. So at the end of the day, I would just say also why. What would be the downside of this? It's $5,000. It's not a great cost to the Commonwealth, and it would have been probably an ironclad opinion if we'd had Dr. Brown, and here we are talking about this.
Okay.
Thank you, Your Honors. I appreciate it.
Thank you very much. We'll hear from the board.
Good morning. May it please the court. My name is Christopher Bova. Today I have the honor of standing in one last time for our colleague and friend David Chennai on behalf of the defendant appellee's Sex Offender Registry Board.
Yes.
Justice Smith
good.
asked the waiver question. I'll start off with that. The board does believe the issue was waived. There was no motion for reconsideration, as Justice Neyman had asked. I believe there is. I didn't specifically look at that particular regulation of the boards, but I believe there is a method to seek to reopen a record post decision. But more importantly,
Is there a mechanism to reopen a request for an expert?
I believe there's ability to seek reconsideration. So if you have an issue with the ruling, you can do that. More importantly, there's certainly an avenue in judicial review in the Superior Court level on a motion to present additional evidence. And that's done 20 days, I believe, after the complaint is filed in Superior Court, which was not done in this instance either. So the board's argument with respect to the research that was permitted in the supplemental record, we do believe is waived. On the motion for expert funds, the panel has pointed out that you're looking at an abuse of discretion standard, whether or not the hearing examiner's decision was reasonable, and that the burden is on the plaintiff for showing that. And it's hard for the plaintiff to meet his burden when his expert specifically states that there's no causal connection between bipolar and sexual recidivism. To me, it's an open
But
and shut case.
isn't that saying that you shouldn't count these against him because there's no evidence that it makes him more dangerous? Isn't that fairly what that sentence says?
I'm sorry, can you repeat that, Your Honor?
He says there's no scientific evidence that this diagnosis correlates with sexual or with criminal behavior.
Yeah.
Isn't he saying that? So this diagnosis is not a risk factor.
Well, he's saying there's no connection to recidivism. So, I mean, there's no quote-unquote risk factor, I guess, in terms of you could apply it to factor one under the board's regulations if there is a mental condition. So that could be considered a risk factor. But in this particular case, the expert's saying there's no causal connection. So when you look at the mental abnormalities under factor one, you always do have that causal connection to sexual recidivism, which is why the board has factor one in its regulations.
Right, but I mean, isn't this explaining you shouldn't consider factor one because there's no correlation between
right,
this
yes.
condition?
Well, yes, yeah, yeah.
He's not saying that. I don't know. Doe 89-230 is the one that talks about special to him, and I think it could be fair to say that isn't where we shouldn't be looking at special to him. He does have these three different factors that two different diagnoses and advanced age, which I also suffer from, but the reg goes beyond 89-230, and it says before you get funds, you have to explain how that condition special to you is connected to the risk of reoffense. And isn't there kind of a catch-22? Don't you need to get the expert to be able to explain that before you can explain it?
No.
Okay.
And I'll tell you why. There are several motions that are accompanied by research. So 89-230 is the seminal case. But the issue with 89-230 is the hearing examiner, after the hearing, went to the DSM-5, pulled all this information out of the DSM-5, and then used that to exacerbate the offender's risk of reoffense. And the SJC said, you can't do that because you're stepping into the role of the expert, making these determinations that the condition exacerbates the risk of reoffense. So that's what 89-230 is. What the burden of the plaintiff is that they have to show the connection, and by doing so, and it didn't happen here, you have the affidavit only of the expert that says there is no connection. There's many a times where these motions are accompanied by scientific articles that specifically speak to the causal connection between the condition and sexual recidivism, in the scientific research articles. There's also instances where you have individuals who are taking certain medications, and the offenders will attach to their motions research articles indicating that the specific medications that are being taken affect sexual recidivism. Now, we do have an instance here.
So I need an expert then to tell you what this report that I'm giving you says?
Well, what they do is they identify the condition. Okay, well, in this case, you have the condition has been identified. It's bipolar disorder, and there's one other one which is not coming to my mind.
Schizotypal.
Thank you. Yeah, schizotypal disorder. So he's identified a condition, but the problem under the case law is he's not identified the causal connection because his expert specifically states there is no causal connection. So you can't. It's not a discovery tool. The motion for expert funds is not a discovery tool. It's to assist the hearing examiner in determining whether or not the condition affects sexual recidivism. And when you have an expert specifically stating that there is no causal connection, it ends.
Well, let me ask you
The
this.
discussion ends.
Counselor, the
Yes.
examiner sustained the board's objection to using Dr. Lewis's ultimate opinion as to dangerousness or risk, correct? Is that correct?
Yes.
But the
yes.
examiner relied on Dr. Lewis. She cited Dr. Lewis, and again, as we discussed, the medication. So the examiner fairly relied on the subsidiary findings of Dr. Lewis, correct?
Yes. So
Very clearly she did.
yes, two separate issues, Your Honor. So the first part of
Well, let me continue first, though.
yes.
So in Dr. Lewis's report, which was appended to the motion, the attorney's affidavit for expert testimony, she makes numerous references which connect Doe's diagnoses to his offenses. And let me just cite a few. Record Appendix 273, she writes, his offense profile is that of a sexual compulsivity disorder, exhibitionism and/or masturbation, and is related to his bipolar disorder. On page 274, he was placed on a mood stabilizer known to manage sex drive and compulsivity. And then and I've skipped over a few references, but then on page 276, she says, given his psychiatric diagnoses and complexity of the way in which they interact with his exhibitionism, his relapse prevention would be best sustained with the addition of other services and treatment. She also says, and I believe this is what the hearing examiner quotes, Doe, is a well-intentioned, socially challenged man whose social disabilities, psychiatric illnesses present a great challenge to him regarding his efforts to live independently, manage loneliness, and problematic exhibitionist sexual impulses. So how is that not making the connection between his diagnoses and what he was found to be a compulsive exhibitionist masturbationer?
And I'd say, I'd say to that, again, two separate issues, two distinct issues. So you have the motion, and then you have the hearing examiner's review under Factor 35, which has been discussed in the board's brief at length. We've already discussed the motion aspect. Okay, you have
We haven't finished discussion of the motion. You mean the motion for expert witness?
motion for expert funds, yeah.
And in the affidavit, again, this was appended to it. So looking at the application, you look at the motion, the attorney's affidavit, the appendix to the attorney's affidavit, which is Dr. Lewis's reports, and you look at the affidavit of the expert, no?
I wasn't aware that it was attached to the expert report. Based upon my review of the record, it was just an attachment to the affidavit of Dr. Brown. So I apologize, but if that was, I still think it doesn't affect the overall situation because the expert that he is seeking to have testify, Dr. Brown, has specifically stated that there's no causal connection. So his testimony and his affidavit is going to control, because he's ultimately the expert that's going to come in and testify.
So, I
So
mean,
you
so-
have,
wait,
you
so-
have essentially an expert, I'm sorry, Justice Master.
Yeah, no, I'm sorry I interrupted you, but Dr. Brown says there's no causal connection. So you can't have an expert come and say, don't hold this against him because there's no causal connection. You can't have an expert do that.
Well, Dr. Brown certainly could have said in his affidavit that, based upon my experience, that individuals with bipolar frequently seek medication and reoffend and whatnot. He has the ability in his affidavit to state other things, which he did not do. He specifically led with the fact that, that there's no causal connection. And then on top
I want
of
to
that,
get, if a petitioner says, I want to get an expert to come in here and say that my mental conditions in no way causes any risk, because there's no connection between it and risk. That's not allowed because there's no connection.
well, right, yes, yeah. Under the case law, I mean, that's under 89230. The burden is on, to get funds, the burden is on the offender to show the condition and then show the connection to sexual recidivism.
But given
So-
what's in this record, following up on Justice Massing's question, these Lewis reports were in the record, and they've been subject to prior hearings. So
Yes.
Doe would go into this hearing knowing that, based on what Lewis is saying, his diagnoses was connected to his risk. And to rebut that, he may want to call an expert to say there is no correlation known between the diagnoses and the risk of reoffense.
But he didn't say that. I mean, but that's not what was said. I mean, that's speculation, with all due respect, it's speculation on.
But what didn't he say?
What did Dr. Brown say?
Yes, what didn't Dr. Brown say?
Well, Dr. Brown, what Dr. Brown said is laid out in his affidavit in paragraphs 7 through 10.
Was the Lewis report submitted as an attachment to the motion for expert funds by Doe?
I didn't think it was, but Justice Smyth indicated there was, so I was looking at the
It's in the
exhibit
record.
list.
It's in the record as petitioner's exhibit. I don't know if it was submitted as an exhibit attached to the motion for expert funds or an exhibit at the actual hearing itself.
So when I was preparing for this case, I was looking at the exhibits that was submitted by counsel, and I didn't see any attachments in terms of the Dr. Lewis affidavits, but again, Justice Smith said in the record appendix it was so.
In either case, it was submitted by the petitioner, by Doe, correct?
I'm sorry?
In either case, it was submitted by Doe.
There were some Dr. Lewis records that were submitted as part of the board's evidence.
In part by Doe, okay.
That was contained within the probation records in one of the exhibits that the board introduced. And I know in the 2021 hearing that the petitioner submitted evidence that was discussed in that hearing examiner's decision. I believe it was a Dr. Lewis letter from 2017 that was introduced by the plaintiff in that 2020 hearing. But there was nothing that I'm aware of in terms of Dr. Lewis being presented at the 2023 hearing, which is on appeal here today. But just to continue further, in terms of the Factor 35 issue that was discussed, and that goes to the heart of the medication issue that Dr. Lewis had discussed. And under the regulations, it's not a risk aggravating factor, it's not an elevating factor. Under the regulations, it's an additional factor that the hearing examiner shall consider evaluative reports and assessments that are being made. So the hearing examiner actually has an obligation to discuss and consider that type of evidence that's presented. And that includes Dr. Lewis and Dr. Schwartz's evaluations. Now, obviously, pursuant to the regulations, the opinions can't come in, but as Justice Smith pointed out, they can consider the doctor's underlying subsidiary factual findings and whatnot. And the hearing examiner is allowed under the regulations to make reasonable inferences. So when you have doctors discussing in 2013, 2014 about the medication and how when he's not on it, his risk is elevated, they are allowed to make those reasonable inferences during the hearing examination, the decision in this particular case, where the attorney during his opening said that he's not on medication, and one of his witnesses, I believe it was a sister, also said that he wasn't on medication. So I think it's a reasonable inference to say that, given the fact he's not on medication today, that there is a little bit of a concern. First, it's not a pseudo-clinical analysis. It's a review of the factual implications of the evidence before the hearing examiner. You also had the witness testimony that said he did have urges more recently while he was off his meds. So I would suggest that's basically a review of the facts of the case and not a pseudo-clinical analysis. So that's the reason you don't need an expert witness to testify with respect to that aspect of the case as well. So unless the panel has any other questions, my time is up.
Came in right under the line.
Thank you so much.
Thank
I
you both.
appreciate
The case is submitted. We have two more for this morning. Next one is 25P 731, which is Blazer v. Blazer, but only Blazer is here today.
Good morning, Your Honors. My name is Corey Arter, and I represent Kevin Blazer. For purposes of consistency with the order, I'll refer to him as father during the argument. This is an appeal of an order out of the Bristol Probate and Family Court dated June 18th, 2024 on plaintiff's complaint for modification of a 2008 divorce judgment. My client, the father, again, for purposes of this case, maintains that the probate court judge erred in two distinct areas. First and foremost, in finding in contempt in the first place, and second, by ordering to pay this lump sum of this $55,000 in change upfront before others obligated to pay any other expenses. The main arguments with regard to that matter are whether the judge erred in finding him contempt where there's no clear mandate that he preserve those funds. So there's not a clear mandate in the separation agreement, and there's no clear and convincing evidence that he disobeyed that clear command.
Okay, so tell me, just as a housekeeping matter, why is the 2022 contempt finding properly before us?
Well, procedurally, and it's kind of a funky procedural thing. So divorce enters 2008, some 14 years later, wife then, when son is getting ready to go to school, files a complaint for contempt because she has a conversation with dad and finds out that that account no longer exists. She files a complaint for contempt. Contempt is heard on September 8th. At that hearing, the judge says orally, well, I intend to find you in contempt, but I'm going to defer to a further hearing where you can present some evidence to the court. Between the time that hearing takes place, or the quasi-hearing, non-evidentiary hearing, mother then files this complaint for modification, which is the subject of the existing order, on September 21 of 2022. Father then files motions for relief, or to vacate the contempt judgment, which interestingly hadn't been entered yet. So contempt judgment then enters, but there's no full hearing on the contempt order. What the judge says in his docket entry, which is all that we have on the contempt complaint, is that I intend to find him complaint, but I'll hear evidence on it. So what happens then at the trial?
Where is that? Where?
It's in the docket entry and in the order. It should be, and I apologize that I don't have the exhibit number.
I've got a judgment of contempt where he finds him guilty of contempt,
Yes.
and then says this court will address his failure to preserve the funds in future court proceedings.
Yes.
So
And
I think he's saying I'm making fine of contempt. What the remedy is going to be, we'll deal with that later.
Well, I would disagree with the wording in your interpretation of the wording. In my view, it says, well, look, I intend to find him in contempt. That's what he says at the hearing. But I'll allow him to present evidence as to why he's not in contempt.
He says that at the hearing? Do we have the transcript of him saying that at the hearing?
I believe I attached the transcript. But more importantly, that order itself says, I will address the failure the contempt is for failing to preserve the funds.
Right. No, but the only thing I've got here,
Sure.
Tell me if there's if there's the transcript of the contempt hearing that took place somewhere between May 27, 2022 and September 9, 2022. like where you say he says, I'm going to.
Sure, absolutely.
Because here he says, it is a judge he's guilty of contempt.
Your Honor, my reading of that,
Okay.
that order is that he says, I'm going to find him in contempt, but I'm going to take evidence as the failure to preserve the funds. The contempt is for failing to preserve the funds. There was not an evidentiary hearing on his failure to preserve the funds. So what he's saying in that contempt order, the September 20...
You're saying I don't need to file a notice of appeal yet?
Sure. Excuse me?
Are you saying so he doesn't need to file a notice of appeal from this because it's still open?
Well, that's where it becomes an unusual thing. So he files motions for relief and motion to vacate the judgment of contempt. He was never given a hearing, and there's no ruling on it. And if you look at the docket sheet, you can see that those motions are filed. But he's never given a hearing on the motion to vacate the contempt.
Right.
So what we're left
Suppose they're
with,
just denied with the judge rights denied on them at
it
some
was
point.
not even denied. There was no hearing, and it wasn't acted on. So what ended up happening is, and I can only assume, is that
I think it was acted on. I think in I see docket entries here where it is acted on.
okay.
On record appendix page, where is it? First on record appendix page 21, motion for new trial denied, reference to 178, motion for relief from judgment denied, reference to 179, and then a few pages later on page 20, RA 24, motion to amend judgment denied, reference 180.
And Your Honor, my point on that is that the motions, he was not ever given, before the time it gets to the trial on the complaint for modification, there was never a hearing, an evidentiary hearing on his failure to preserve the funds. And in fact, the judgment of contempt says, I'm going to hear evidence on the failure to, if the contempt itself is for failure to preserve funds, and that's the only act that he's being held in contempt for, and there has not yet been a hearing on his why he didn't, or a failure to preserve the funds, I would suggest, Your Honor, that there wasn't a final judgment on the contempt. He wasn't given a hearing on either of his motions to clarify that or to have an evidentiary hearing on it. Notwithstanding that, what the judge is doing, both by finding the father in contempt for failing to preserve those funds, and by then latering a lump sum payment of these funds, is he is interpreting a provision in the contract, which is the error, that it survives as an independent contract. I mean, there's no doubt in reading the language of the separation agreement, both in the preliminary boilerplate language and in Exhibit B itself, that the provision with regard to this Symmetry Partners account is a provision related to marital debt and personal property. Throughout the separation agreement, drafted by attorneys and drafted with full knowledge of what that meant, they said that all provisions related to the personal property of the parties, including this account, shall be incorporated but not merged, and shall maintain an independent legal significance. So if
is your argument from that there's no order that the judge, because it's covered by the separation agreement, the judge can't order payment of college payments unless there's something more than a material change circumstance?
Sure. Yes, he absolutely has the discretion to order payment of college expenses. I would say that's two different things. In fact, he did. So, there's two things. The one issue that's being appealed is whether or not he had the authority to say, you're in contempt for not maintaining this specific dollar amount and paying that specific dollar amount over to the college, where one, there's no language in the separation agreement that he had an obligation to pay for college expenses. That being said, a judge in the probate court does indeed have the ability to, if he seems fit, order payment for post-secondary educational costs along with child support, and can modify it.
He did have an obligation to preserve the funds. So let's go to the language.
Sure.
Okay. Exhibit B to the separation agreement. First of all, this paragraph is captioned "college account for children."
Sure.
And then we go to the core sentence. The current balance is approximately $56,600. The husband shall preserve these funds for the future educational expenses of the minor children. The next sentence, however, this paragraph shall in no way be construed to restrict the husband's ability to invest and reinvest the funds in any manner he so chooses. So what is meant by shall preserve these funds?
And I would suggest to you again, if you go back to the intent of the party, and there's very clear language
Start with the
or
language.
saving.
Let's start with the language.
Sure.
What is meant by shall preserve?
Yeah, and if you read the paragraph as a whole, you can't disregard the last part of that paragraph. The part of the paragraph added by counsel and the parties is that nothing in this paragraph shall prohibit father from taking that money, investing and reinvesting it as he sees fit. So while it does say, hey, it's our...
Can't you read them together to say he shall preserve them, but he can also reinvest it as long as that money is preserved, as long as that $56,500 is ultimately preserved?
And again, that, I don't think that
The use of the term preserve, to me, is significant.
Sure. And I understand your point, and I don't think that we can take the words out of context from the remainder of the language in the paragraph. If you look at the remainder of the paragraph, it says it's his intent to use it, and then it says that he can preserve it, but nothing in this paragraph shall limit his ability, and I apologize if I'm not quoting verbatim, nothing in the paragraph shall prohibit him from taking this money, investing it, and reinvesting it as he sees fit. That was 16 years ago. Okay, over the course of time,
He put it in Bitcoin and other, at least he says, he put
Yes.
in Bitcoin and other risky strategies and lost it.
Sure, absolutely. And my reading of it, and certainly not to make light of it, but if it says you can take this money, notwithstanding anything else in the paragraph, that you intend to use it this way, that we think you're going to use it this way, we want you to preserve it, nothing in this paragraph prevents him from taking that money and doing something risky, taking it to the dog track, investing it however he wants. And again, not to make light of it.
He's
but
taking to the dog track, he's really not preserving it, is he?
He's not preserving it, but he's taking it and he's reinvesting it however he sees fit. So they put that saving language in there for a reason. And again, they're both represented by counsel.
Isn't the saving language to say, look, you can invest in other strategies. You're not limited to keeping this money with Symmetry Partners.
Sure.
But at the end of the day, regardless of what you do with it, you have to preserve it. There has to be at least $56,600 in there for future educational expenses of the minor children.
And again,
Otherwise, that sentence seems to me to be meaningless and illusory.
even if it were, for the sake of argument.
I say seems to me. Maybe I'm wrong, so I'm curious what.
And to me,
why
I don't think
would
that
be wrong.
I don't think the last part of that sentence would have been put in there if it wasn't the intent of the party that that was his personal property. He could take it, he could invest it, he could reinvest it, he could do what he wants, while he intends to take this dollar amount and maintain it. I mean, I don't think that it's I don't think it's lost on me that there is language in there that starts out, I intend to use it for this purpose, and it should be saved. However, if you specifically put in language that you can then take that money and you can withdraw it, and you can invest it somewhere else. And again, the judge doesn't say, I discredit that he did that. You know, he takes it as, he credits his testimony. He says, okay, even if I were to believe that you took the money and invested it somewhere else and lost it all, I still think you're obligated to pay it. You know, which again then leads us in, and I see my time is getting short, which leads us to the next thing. Let's assume for the sake of argument that he was in contempt, and he took this money and he got rid of it. Then we're back to basic probate court judge looking at this case and attributing, which he has the discretion to do, an ability to pay a certain amount towards college education. Judge credits the financial statements, tax returns, wage information from father. Looking at that, not only does he acknowledge that he doesn't have this money anymore, he doesn't have the present ability to pay it, he reduces his child support because the financial situation of the mother had improved so much since 2008 that his child support is then reduced. And then he acknowledges on the record that, you know, as a judge, you know, the guidelines say I can order up to 50% of in-state tuition, which in this case was the $17,000 number that he had. Nowhere does it say that, you know, he has the discretion to, one, order more than father has the present ability to pay. The guidelines are there for a reason. The guidelines are there so that the court can weigh the financial situation of both parties. He credits both parties' financial statements. He says, I've looked at his tax, I credit it, this is his income, this is her income, this is what I say that he should be able to pay. So the order is contradictory to itself.
Is present ability to pay a factor that is delineated in the guidelines?
Yes, and I believe that I cited.
So, sorry to interrupt you, but where the judge says in his last sentence, after considering the required factors contained in the guidelines, the court finds father should pay 1/3 of the children's post-secondary educational costs. So if the judge is says, I've considered everything in the guidelines, isn't that inclusive of present ability to pay?
But it's two distinct things. I mean, he first just throws this lump sum out there. I know you don't have it. I don't see it in any of your accounts. I know that it is gone. But
I don't think the judge says, I don't say, what the judge repeatedly said, the father testified, I have these accounts, but I have no idea as to the account balance. Court doesn't credit it. I mean, I could go through the judge's findings. There are repeated findings where the judge does not credit the father's purported lack of knowledge or loss of funds without explanation.
But what he does, and again, so that goes back to, I can even assuming, okay, he doesn't buy it, and he holds him in contempt for that. You're still back to square one. The guidelines, when you're considering awarding costs for post-secondary educational expenses, you've got to consider the respective incomes of the parties. And in this case, he actually found that the respective income of the parties had changed so much that he was not obligated to pay the amount of child support he was paying. He reduced it. He did hold that he should pay 1/3 of post-secondary educational expenses. And if you look at the rules and the discretion of the judge, it's up to 50% of in-state tuition. And again,
And he bases it on 1/3 of in-state tuition, right?
Sure, and he even goes less. So he does each of the parties shall pay 1/3. That number, this magical $55,000 number that he assesses first, actually flies in the face of his other conclusion that, okay, I think he's obligated to pay 1/3 of the in-state, and he's only obligated to pay this amount in child support. He reduces.
How do you read the two parts of the order? How do you read them together, or do you read them together?
I
What is,
don't.
so, speaking of, clear and unequivocal, what does this order say that your client has to do?
It says that he's got to come up with this magical amount of $55,000 that he does not have anymore in response to the alleged
okay, so you got to come with that first, and then after making that payment, he shall pay 1/3 minus, 1/3 based on UMass minus scholarships and grants and stuff like that. So does the 55 go towards the 1/3, or is it?
And I don't think that's clear. I think that's also part of the issue is that, he orders this lump sum, then he also orders this 1/3 of tuition. So now you've got sort of a double whammy for this guy. He finds that based on the financials, he's obligated to pay this amount and the 1/3, but then he also says, hey, on top of that, I'm going to put this magical $55,000 that he doesn't have anymore, and he doesn't show in any account, and there's no evidence that he has the ability to pay.
So on the, at the end of your brief,
Sure.
you say, based on the foregoing, the judgment and order of the trial judge finding father in contempt and ordering payment of $56,868.22 must be reversed. Is that the only thing you're asking for?
Yes, I don't disagree with the judge's discretion in ordering the 1/3 of the in-state college tuition and/or the child support that he orders. Those were designed and adequately ameliorate any need of the children. That's what the child support guidelines are designed to do. So this retroactive, interpretation, if you will, of the surviving contract provisions is not the only remedy. The remedy for ameliorating the current need of the children would be the child support guidelines and the entry of the 1/3 of the tuition going forward.
Okay, I think we understand your argument.
Okay.
Thank you.
Thank you.
And we do understand your argument. That case is submitted. We have one more for this morning. Customarily, we take a break here, but I think we're going to power through it. Last case is Sanderson versus Arthur ZACK and another, 25P 793.
morning.
Morning.
May I proceed?
Yes.
Good morning. Scott Kramer on behalf of the plaintiff, Tanesha Sanderson. She's here today, sitting in the audience.
Morning.
Morning. This is a legal malpractice case that she brought against her workers' compensation lawyers. It was a case that in the lower court, the court granted summary judgment on statute of limitation grounds and dismissed the case, and we're here today for the de novo review of the matter. To cut to the chase, when you look at the facts and the evidence in the light most favorable to Ms. Sanderson, as you need to, you see there's certainly at least a question of fact for the jury when it comes to whether or not, or when the cause of action accrued. And this just came down, I believe, on the 2nd of February. The First Circuit Court of Appeals has just issued a decision in the Blue Radios case. It's Blue Radios versus Hamilton, Brooks, Smyth, and Reynolds. I have copies here if the court would like it, where they address the issue of...
Don't need copies, but we need a cite.
Okay. Well, it's... I don't know that it has a site yet, Your Honor. It is docket number 24-1942 of the First Circuit Court of Appeals. And again, the plaintiff is Blue Radios Incorporated versus Hamilton, Brooks, Smith, and Reynolds, PC, et al.
Sounds like it sounds like it's a malpractice case.
It is a malpractice case. It's a 60-page decision where the First Circuit, when you look at it, you look on page 22, they talk about the fact that they're trying to give a primer on how accrual dates for statute of limitations should work in Massachusetts. And what you see from what the First Circuit says here, essentially, it should always be a question of fact for the jury, except in very, extreme situations, which isn't this case. This case, there's certainly a question of fact from the jury as to when this cause of action accrued. This is a case that goes back to 2013. Ms. Sanderson was injured while she was working as a nurse.
So we know that there's a settlement comes for $65,000. It's under suspicious circumstances. The attorney asks her to sign documents that are blank, and she tells her, "I'm about to retire. It's time for me to make some money off of you." All this is right. This is right around March. So, and then she gets a settlement that she knows she never agreed to.
Well, that's not exactly true, Your Honor. When you look at her testimony from her deposition, we cite it in the brief and it's attached. Her understanding, this is in March of 2017 when she's talking with her lawyer, and she is someone who is trusting her lawyer. Her lawyer is telling her, you have no choice, you have to settle for the $65,000, there's nothing, this is all, you have to do this. She is told that. She doesn't like that. She's still injured. She's still having trouble. She's still concerned. But she's being told by the lawyer who she trusts that this is what you have to do. So she says, okay, I'll do what you tell me to do. You want me to sign documents? I'll sign documents. Whatever you say, right? What she doesn't know at the time when she's doing all that, because her lawyer never told her, was that by doing that, she's going to give up her right forever in the future to seek further benefits if, in fact, her condition worsened, which it did, and which it was doing at the time she was being told to do this. So this wasn't a situation where, in 2017, she was doing something that she knew that the lawyer was telling her to do that was wrong. She thought the lawyer was telling her to do the right thing. She was following his instructions. She was following his advice. And, it's all over this First Circuit Court of Appeal decision where they talk about how it's perfectly justified for clients to rely on their lawyers and to not have to think they have to second guess them. She was told what to do. She followed her lawyer's advice. Ultimately, that advice was wrong. Ultimately, that advice cost her the ability to seek additional benefits. This was a situation where this firm represented her until February of 2021. Right, under the continuing representation doctrine, her statute of limitations would be told until that point.
So let's talk about the continuing representation doctrine. That doctrine requires that there be reliance in some form. And it's my well, let me ask you this. What evidence is there in the summary judgment record that after your client received the lump sum settlement, she relied on advice or anything involving continuing representation? Where can you point us to?
Certainly. I mean, there were the emails.
Which email?
The emails from November of 2018. I'll tell you where they are on the docket.
So that's Record Appendix 213.
Correct. You know, from 2017 through 2021, and it's in the record, and it's in the client's deposition that's part of the record, she's having ongoing problems getting her treatments, getting it covered through her workers' compensation, and she's going back to the lawyer for assistance with regard to that. And then in November of 2018, once she realizes that her condition has worsened and she wants to get her additional benefits under workers' compensation, she's told that she can't. That's when she has this conversation with the defendant law firm where essentially they talk her out of doing it. Regardless of that, even if you were to use November 6th of 2018 as the accrual date, that's still within 3 years of when she filed the lawsuit.
Record Appendix 213 is a one-page email. It's clearly part of a larger chain, but we don't have the rest of the email chain in the record. So we don't know what she was asking, she being your client.
Well, I can represent, Your Honor, that the emails that are in the record are the emails in total of what we received in discovery. And I would say it certainly at least raises a question of fact.
Your client sent the initial email, I would think. So, in any event, okay.
In any event, I would say, Your Honor, again, I think that's more of a more sort of evidence that we're dealing with a question of fact here as to when this accrued, which is something for the jury or the fact finder to decide at trial, not for the motion judge to have decided. And certainly not the way the judge decided it, which was to say when she got the check, that's when it accrued. That's certainly, there's certainly evidence that points strongly against that.
How do you respond to their argument that there's two different representations going on? There's one with respect to the workers' comp claim and one with respect to the continuing benefits claim, and that they're representing her together. So this lump sum doesn't, right, if I understand it right, the lump sum doesn't affect her ability to get payments for continuing treatment, and right, and you can go back for that. And they're representing her and trying to get getting that money, but no longer representing her on the workers' comp claim. How do you address that?
Well, I think that would be, again, splitting hairs and creating, again, more questions of fact. I mean, it's the workers' comp claim. They were the workers' comp lawyers that she hired. They helped her, they helped her through the whole process, which included negotiating a settlement that was incorrect and continuing to help her when she was having problems getting her treatment. This idea that they can split there was no separate representation, there was no additional fee agreement or anything like that. This was all of a piece. They were her lawyers.
Do we have the fee agreement or the representation agreement in the record?
I don't recall, Your Honor, because I don't know if there was. I don't recall off the top of my head whether or not there was one. But my point is, this is all of a piece. You can't separate out. Oh, okay. Well, we represented you for the workers' compensation claim up to this point. But now our representation is only limited to this small part. I mean, I would suggest, Your Honor, that doesn't necessarily track, and also I would suggest that that's a question of fact. So, that's essentially the issue with regard to the statute of limitations. I'm happy to answer any of the questions you have about that. But, she received bad advice in March, and she filed within a few months of the end of the representation in February of 21, and she filed certainly within 3 years of that email chain where she discussed.
So I'm going to go back to my earlier question. Where's the reliance in terms of the continuing representation doctrine? You point out the email at Record Appendix 213 where it seems that you're arguing that she arguably relied on them not to sue them on that date, because the woman says, I talked her off the ledge. Where is the reliance on anything involving continuing representation or anything involving a
Well,
workers' comp claim?
They continued to act as her lawyer until February of 2021, assisting her
How so?
with the issues with regard to the treatment she was getting.
Okay.
And they were still acting as her lawyer.
So where can I find that in the record appendix? That's what I'm asking, because I don't see that in the email. I'm not sure I see that, at least with reference to dates, in her deposition testimony.
Hold on a second. One moment, Your Honor.
Well, let me just, to save us time, those would be the two places it would be, correct? It would either be in an email or in deposition testimony? Is that correct?
Correct, Your Honor.
Okay. Then I understand our universe of information. Thank you.
So that's essentially the argument. There was a question of fact here. This was not an issue that could have been decided on the summary judgment stage. And she should be able to have her day in court, have her trial, and let the fact finder decide when did the cause of action accrue? Did she file timely?
The defendants raised a lot of other issues in the summary judgment motion that the judge didn't address.
Correct.
And they revived them on appeal. And you don't really respond to them. You don't respond to them. You have a short section about that there's material issues of fact.
Correct.
Could you help me with they're going to come up here and argue that she's not even eligible for benefits under Section 34A. And can you respond to that?
Again, that's a question of fact. We've submitted, and it's in the record, the expert reports both from her treating doctor and by an expert who reviewed the file, who both opine that she is, permanently and totally disabled from all employment, which is the standard that would be applied to determine whether or not she's entitled to benefits. And again, that would be part of the question for the fact finder or the jury at trial to determine whether or not they believe, whether or not they agree that she should be entitled to the benefits.
So the lump sum payment was based on less than a total disability?
Correct. Right. There was about another $65,000 in 35 benefits that was available, and running out of time here. And with the 34A benefits, it would have been $886 a week for the rest of her life, starting at age 35. So, unless there are other questions, I'll rely on my brief. Thank you.
Thank you.
Thank you.
So the attorney ZACK is represented by attorney Mafucci, and then the firm is by attorney Storm. Who's going to go first?
I'll go first, Your Honor.
And you are?
Storm.
Storm?
Yes.
Okay.
From my point of view, Your Honors, and may it please the Court, Chris Storm for Feinberg, Campbell, and ZACK. I think you have a good understanding of the issues in this case. I'd like to talk to you about two reasons today why summary judgment should be affirmed. Number one, the statute of limitations was not met here. And number two, there is an ultimate failure of causation warranting summary judgment for the defendants. With regard to the statute of limitations, I certainly believe that this was not one continuing representation. This is a workers' compensation representation that terminated with a lump sum settlement agreement in March of 2017.
Where's the evidence in the record that it terminated? at
The
that
evidence
point?
would be the lump sum settlement agreement, Your Honor. Now, the way comp settlements work, generally speaking, they're settled with medical left open. And that's because it's a remedial statute that's intended to be beneficial for employees. And I would submit that it cannot be the rule in Massachusetts that when a comp attorney settles a case with medical left open, that if a client comes back any number of years in the future, because this is an open-ended type of statutory regime, that the statute of limitations
Question
never
isn't
has an
how it
endpoint.
usually works. The question is, what is the evidence in the summary judgment record about whether there was continued representation and
Yeah.
what went on during that continued representation?
Right. And I believe, Justice Neyman, you asked the question about specifically where in the record it is. I believe it is essentially that one page that hints at, but does not directly point to the fact that Feinberg, Campbell, and Zack may have assisted Ms. Sanderson trying to obtain insurer payment of medical bills for which the insurer was recalcitrant. That's a completely separate suite of services than representing someone up to a lump sum settlement agreement and lump sum settling a case. It's essentially on the order of a breach of contract claim against an insurer pursuant to a settlement agreement, as opposed to trying to prosecute a workers' comp claim. Now,
So I know you argue that the plaintiff is a sophisticated individual, but how is even a sophisticated, medical professional can understand the difference between that the same lawyers are still representing her on a related claim? How is she going to understand that, oh, they're not representing me on this, but they are on this?
one thing that the record is really clear on, Your Honors, is that Ms. Sanderson was told there ain't no more fruit on that tree, right? She testifies in her deposition that she was told the reason that she needed to settle was because Attorney Zack thought she had a residual work capacity. She was young. She had a master's degree. She worked in the emergency room at a busy Boston hospital. And the standard for 34A disability, which I'll get to in a minute, is complete and total inability to perform any kind of work in the future, not to return to your former employment, right? And not disability for 1 year, which is the Social Security standard. So I think it's relevant there, Justice Massing.
Was there a fee agreement here of any kind?
I don't think it's
in the record.
I don't think it's I don't think it's in the record, Justice Neyman. Now, another reason that the continuing representation doctrine does not apply is because there is no innocent reliance here. Okay, the continuing representation doctrine applies when a client does not know that he or she has been harmed, but the record here is replete with evidence that Ms. Sanderson believed and understood that she was harmed. Some of the words that she used in her deposition was that she was very uncomfortable, she was in disbelief, she was uncomfortable about settling. These are record appendix pages 86 and 87. Somebody who did not want to settle. In connection with settlement, an affidavit was executed in order to excuse Ms. Sanderson from appearing at the lump sum settlement approval hearing. When presented with the affidavit, and again, this is not a pre-printed form, Your Honors, this is a typed out affidavit, she stated that she could not recall if there was a single letter, a single piece of text on the page. When she contends that she was provided blank documents to settle, she doesn't just mean workers' comp forms that were not completed. You know, her deposition testimony is ambiguous about this. She says she doesn't remember. She's suggesting that the pieces of paper were blank white pieces and she was told to sign here.
But I mean, Attorney Kramer argues that exactly that. She was told to sign here. Her advice of counsel was, just do what I say. This is all you're entitled to. Why is that innocent?
Because
isn't that innocent reliance?
No, Your Honor, because anybody would understand that being presented completely blank pieces of paper, being told it's time for me to retire and make some money off of you, and sign here in connection with a legal proceeding.
We're talking, I think, at cross purposes. Doesn't the continuing representation doctrine begin after the lump sum settlement has made?
Well, I don't know that I necessarily agree, Your Honor. I think that the bell is tolled when something happens in connection with the representation that causes the client to believe that she has been harmed. At that point, the fact that she comes back to them in 2018 and asks for help getting a bill that's outstanding paid, that does not erase the fact that she already testifies in the record that she believes she's been harmed. I think the cases are as I view it on that one. And by the way, with regard to the Blue Lagoon case, just the Blue Radio case, while we're on the point, I did review it before standing up here. They don't address the continuing representation doctrine. They address the question of lawyers appreciating that they've been harmed. A client's appreciating they've been harmed. I believe it's very distinguishable from this case. That's a patent case. The court says in that particular case that
I just took a look too. It stands for the broader proposition that generally, as Attorney Kramer said, these cases are not typically suited for resolution at summary judgment.
Right, and the specific situation there was the receipt by a client of a technical and complex patent document. So I don't think it is really on point here. With my time growing short, I would like to briefly address the causation argument, which the motion judge did not address and which is an equally sufficient basis to affirm summary judgment. It's the plaintiff's burden to prove causation. She needs to prove that she would have been entitled to 34A benefits. At the time the case was settled, there was an independent workers' comp physician's decision or opinion that she had a work capacity. She admitted in deposition at the time of the settlement she had never been told she was completely disabled. She had never tried to seek employment. She was operating two different businesses.
She didn't admit, I don't think it's fair to say that she admitted that she had never been told she was permanently disabled. She kept responding, "I don't know." Response to all of the questions.
Well,
that's how I read the deposition.
So she was asked, Your Honor, did any doctor ever tell you at any point that, because I remember this question, that you were permanently disabled? And she said no. She says that no doctor ever told her that she was permanently disabled. She was operating two businesses, a bus company in Jamaica and a...
I think your time is up. We'll have to leave it at that.
Thank you very much.
Thank you.
May it please the court, Christopher Mafucci for appellee defendant Arthur ZACK. The cause of action accrued when plaintiff received the lump sum check. That is the last possible point, okay? It actually might have accrued sooner because she was warned and she knew and she understood that there were things that her lawyer was doing, according to her testimony and statements, that she believed was a perception of harm or injury, okay? She didn't want to settle the case. She testified to that. She says she was forced to sign blank documents. She says, my attorney told me, just sign these and we'll take care of everything and we'll be done with the case. Okay, done with the case means finished, not we're going to do something later on. So she wasn't happy and understood that the time that the settlement was being discussed with her that it would terminate. She knew that. She knew that. And she says she was very uncomfortable.
Excuse me, for purposes of our analysis, at what point on the time continuum does our analysis of the continuing representation doctrine commence? Is it after she receives the lump sum settlement, or do we go back in time to a time prior to that?
I believe at the lump sum settlement, when she received that settlement and she took the check and cashed it, that was when Arthur ZACK's work was done representing his client in the workman's compensation. That's when that's the marking point. Now, moving forward, okay, under the settlement, the plaintiff still has the ability to get payments for medical care related to the injury that resulted in her seeking and obtaining workers' compensation insurance and benefits. She did that occasionally after the representation was over to seek help with getting payments, okay? And that's what my brother was discussing, was that this is always going to happen in perpetuity until the day that she dies. The workers' compensation insurer is always going to be responsible for paying for medical treatment related to the underlying injury and treatment. So looking forward then to the continuing resolution of continuing representation, that's not continuing representation. It can't be, because it never ends. So it's not, it's got to be separate.
Well, this email, it says, this is coming from Attorney ZACK. Tanesha is just messing with you. Don't worry about her. Just get the bills and get Keith to pay for them. So he's still actually representing her in terms of the medical.
Absolutely.
Right?
But that's not part and parcel of the underlying representation for the workers' compensation benefits. Okay, that's part of the settlement.
How does she know that?
How does she know it?
Yeah.
Because she's getting
he's still
the benefits.
he's still representing her a year and a half later on something that's related to it.
No, I disagree. I think the evidence is such that the settlement, lump sum settlement, is for the 34A benefits that she might have been entitled to and the Section 35 benefits that were almost exhausted or going to be exhausted. Okay, but the carve-out in the law for these workers' compensation claims, as noted, it's a remedial statute. It is for the continuing payment of medical bills related to the underlying treatment. So to say that that's all part of the same is just, it's an untenable position for the workers' compensation attorney, because they're always representing, if the court takes that view, we're always representing the claimant till the day of the claimant's death.
It's not totally untenable. You could have fee agreements that explain exactly what the scope of the representation is. It's not totally untenable, but.
Yeah, I guess that could be explained. But again, there are other reasons other than the ones discussed, arguments in our brief, such as the fact that the 34A candidate, plaintiff was not a 34A candidate because she was not totally incapacitated. The evidence is undisputed that she is not incapacitated, permanently and totally disabled, which is the requirement for being awarded 34A benefits. Okay, the evidence is clear. There's no dispute that she operates businesses, a bus company in Jamaica, but also a rental property in Florida. And besides that, her education and abilities, she's not a coal miner digging rock inside a cave. She is an educated nurse, and she has a master's degree. She could not, there's so much work potential. And the record is clear with the evidence of Dr. Limke, the IME specialist, who said she was capable of work back in 2016. She was capable of light work, light duty. Then there's the vocational expert, Nancy Segrave, who listed a whole bunch of occupations and work that claimant was could do at her current stage of limitations because of her high degree of training, skill, and education. So between running businesses, okay, which in itself is work, obviously, and, you know, her training and education, there's just no possibility that this was even any chance of her winning Section 34A benefits or obtaining Section 34A benefits under the law. And therefore, there's no possibility of causation. There's no injury here because she was never going to be capable of obtaining Section 34A benefits, which is the gist of her damages. So there's no causation, there's no damages, there's no injury.
All right, well, that's the red light flashing. We'll have to leave it at that. But you know, thank you all, very helpful arguments, and the case is submitted. And that is all we have for today. So I want to thank the court officers, thank the clerk, and we're going to be in recess. We'll come out in a few minutes to greet our visitors from Boston College Law School.
Thank you, Your Honors.